Hi guys, happy Monday, good evening, January 5th, 2026. This is part two. Maduro dancing, Taco, Clayton, Rubio crying because I think Maduro's going to prevail. Here we go.
United States v. Nicolás Maduro. Why this case fails at the jury level erodes institutional credibility and sets a dangerous precedent. Executive summary, read first. The prosecution of Nicolás Maduro is legally permissible, but structurally unconvictable before a jury. The core failure is credibility collapse, not statute or evidence volume. J. Clayton functions as an institutional legitimizer who collapses law into executive loyalty. Public framing by Donald Trump and Marco Rubio contaminates jury perception by casting prosecution as state power, not neutral justice. The indictment aggregates decades of allegations with weak personal nexus to U.S. territory. Jury conviction probability is low, less than 25%, regardless of allegation severity. Courts are likely to contain, not endorse, the precedent. Astrology confirms behavioral inevitability. Clayton over-legitimizes, Trump over-declares. Maduro survives through ambiguity. This analysis predates media consensus and demonstrates independent, anticipatory reasoning. The case will be remembered regardless of verdict for what it tests, the boundary between law and power. 2. Key actors, why framing matters. Nicolás Maduro, indicted in absentia, never in U.S. custody, still de facto head of state. J. Clayton, former SEC chair under Trump, now SDNY U.S. attorney, political appointee with loyalty baggage. Donald Trump repeatedly frames prosecutions as instruments of state power, not neutral justice. Marco Rubio articulates shifting, contradictory rationales that undermine prosecutorial coherence. Locked thesis, credibility plus independence is the whole case. Once that collapses, evidence volume no longer matters. 3. The 8 prosecutorial red flags documented. 1. The why now? Failure, dormancy since 2011. This case has been in the Southern District since 2011. Maduro was charged in 2020. Not new evidence. Not a new emergency. Not reactive. Translation. We sat on this for a decade. Now we're activating it because politics changed. A real prosecutor explains why now. Clayton never does. This omission becomes Exhibit A in dismissal and suppression briefing. 2. The superseding indictment tell procedural smoke. Emphasis on superseding indictment. Furthering those charges. Additional resources. Absent. No new overt acts. No new jurisdictional hook. No new custody nexus. Diagnosis, indictment laundering, recycle, repackage, reannounce. Not illegal, weak. 3. The immunity dodge, legally fragile. We never recognize Maduro as the duly elected leader. Head of state immunity does not turn solely on U.S. recognition. Courts examine. De facto control. Effective governance. International practice. Executive consistency. Outsourcing immunity analysis to press conferences is not law. Judges will scrutinize selective use of recognition doctrine. 4. Noriega/Bin Laden analogies, bad law. Cited, Noriega, Bin Laden, Pan AM 103, Benghazi, Syria. Those cases involved armed conflict, combatants, UN resolutions, war zone capture/extradition. Conclusion, Maduro is not equal to Noriega legally. Maduro is not equal to Bin Laden factually. Moral equivalence masks legal mismatch. 5. Chevron/oil question, the non-answer. Asked directly, is this a pretext for oil and minerals? Response, law school questions, idiosyncratic, white hat. That is deflection, not denial. Clayton never states, resource considerations played no role. Silence here is probative. 6. Due process performance, values theater. Overperformance. Presumption of innocence. Rule of law rhetoric. Subway anecdotes. Public safety narratives. Signal, confident prosecutors talk evidence. Exposed prosecutors talk values. 7. The Mexico hypothetical, selective enforcement trap. Asked, if Venezuela, why not Mexico? Answer, idiosyncratic, case by case, will build cases. This admits selective enforcement. Selectivity plus politics equals equal protection risk. 8. The fatal tell. If it doesn't work for the American people, they can impeach Trump. This is not prosecutorial language. It is political contingency signaling and devastating before a jury. 4. Indictment reality versus trial reality. Strengths. Broad conspiracy narrative, narco-terrorism, cocaine, weapons. Co-conspirators and prior guilty pleas. Statutes with extraterritorial reach. Weaknesses. No clean causal chain tying Maduro personally to U.S.-bound shipments. Leadership inference replaces proof. Decades-long scope dilutes clarity. Predominantly foreign conduct weakens nexus. Conclusion. Sufficient for indictment. Poor for jury conviction. V. Jury psychology, the silent decider. Jurors will ask, why now after a decade? Is this law or foreign policy? Would this exist without this precedent? Why Venezuela, not Mexico? Why is the prosecutor speaking politically? Once these questions arise, conviction probability collapses. 6. Defense motion roadmap, ordered, predictive. Illegal custody/release. Sovereign immunity. Jurisdictional dismissal. Venue change. Discovery compulsion. Bill of particulars. Suppression. Reverse jinx. Evidentiary motions. Motions in limine. Rule 29 acquittal. Sentencing/appeal. Priority. Immunity plus custody define authority. Discovery defines battlefield. 7. Core finding the 3 conflicting rationales problem. 3 different stories. 1 defendant. Structural failure. At the heart of this prosecution is a fatal incoherence. Trump, Rubio, and Clayton advance 3 incompatible justifications for the same extraordinary act. They do not align. They do not reinforce. They cannot all be true. This is not messaging failure. It is a rule of law failure. 1. Trump's rationale Venezuela as resource prize. Make Venezuela rich again. U.S. oil companies. Resource control. Corporate compensation. This is economic restructuring, not criminal adjudication. 2. Rubio's rationale. Geopolitical denial. We don't need Venezuela's oil. Prevent China, Russia, Iran control. This is foreign policy containment, contradicting Trump. 3. Clayton's rationale. Detached drug case. Narcoterrorism. Cocaine. Fentanyl rhetoric, not charged. Clayton ignores. Venezuela as a country. Oil. Geopolitics. Executive statements. His case exists only if the other 2 stories are ignored. Result. Judges see pretext. Juries see confusion. 8. Rubio's contradictions and selective enforcement. ABC, Stephanopoulos. Honduras president convicted pardoned. Maduro indicted extraordinary enforcement. Rubio deflects, claims ignorance, articulates no neutral principle. Selective enforcement does not require malice, only inconsistency without standard. NBC, meet the press. We don't need Venezuela's oil. Then immediately. Prevent adversaries from controlling it. Oil is framed as geopolitical denial, not domestic need, irreconcilable with Trump's enrichment narrative. The press failed to press this. Defense counsel will. 9. Missing conduct not charged. Clayton omits. 35 plus boats bombed. Oil tankers seized. Maritime escalation pre-custody. If legally relevant, they would be charged. If politically relevant, they are concealed. A jury notices omissions. X. The Lindsay Halloran deja vu doctrine, Comey case. Definition. An institutional validator is used to normalize an extraordinary political act. Their credibility becomes the shield. Clayton mirrors this role. Appears technical. Performs legitimacy. Signals loyalty. Difference. Halloran advised. Clayton prosecutes. History judges the uniformed enabler more harshly. 11. Astrology overlay, behavioral compulsion. Clayton. Authority alignment, overexposure, credibility erosion. Maduro. Survival through ambiguity. Trump. Over-declaration backlash, 2026 to 27. Synthesis. The case cannot resolve cleanly. It fails at the jury level. 12. Dangerous precedent doctrine. A clean win would normalize. Criminal prosecution as geopolitical enforcement. Recognition doctrine as immunity eraser. DOJ as executive extension. Courts will narrow and contain, not bless. 13. Final finding locked. Is J. Clayton the reason the case struggles? Heavy checkmark credibility failure, point heavy checkmark collapses law into power heavy checkmark makes weaknesses visible. Crossmark not the only flaw, the accelerant. 14. Closing statement. The failure of United States versus Maduro will not be a failure of law. It will be a failure of restraint, and the proof will be the people who spoke when silence would have preserved legitimacy.
Okay, guys, that's part 2. He most likely is going to be dancing out of there. Okay?